All right, everyone, welcome. Welcome to the webinar tonight, Estate Planning for Retirement, 5 Steps to Protect Your Legacy. So we'll go through and make sure that you cover all those 5 steps with me, which are safeguarding your estate, planning and knowing what to do in an updated will, ensuring your superannuation and your other assets that might be non-estate assets go to the right people, minimizing tax where we can, and really thinking about appointing the right decision makers, not only for a situation where a will might come into play, but also for your financial and healthcare decisions while you're still alive. So welcome. Thank you for joining us. Where there's a will, there's a way. A lot of you have probably heard that saying. It's funny, I found who said it. Sam, back in 1859. Anyway, that's what a lawyer does. So my name's Jackie Broman. I am the Wills and Estates Specialist at SPG Lawyers. I joined the team in January. I moved up from Victoria last May. I had been running my own practice down in Victoria for 12 years, but had sold that practice last January and worked through for the new owner for a period of time, then had 7 months off, which was lovely, mid-career break, and have returned to work. In Victoria, I obtained my specialist accreditation. So I did that in 2016. And just for those who don't know much about the legal industry and know I suppose, the professional process. So yes, once we have a law degree and we go through the various things to qualify, we can practice as a lawyer. Then you can do additional training in all sorts of areas. So I went on and did an applied master's degree in wills and estates. And then after that, I did a 12-month examination process with the Law Institute of Victoria to get that accreditation. So I hope doctors don't take offense to this, but in the medical industry, it might be similar to saying, well, you've got GPs and then you've got specialists in certain areas. So in Victoria, I knew that there was about 22,000 lawyers in Victoria alone. There won't be that many lawyers in Queensland. And of the 22,000 in Victoria, only 80 had the accreditation in wills and estates. And so the numbers are smaller in Queensland, but you watch out for that accreditation logo. Mine says Law Institute of Victoria at the moment. It will say Queensland, but it's mainly the figure 8 to look out for. So lawyers can get accredited in lots of different areas. Just a little bit of background. So we're going to kick off straight away by talking about safeguarding your estate and the way that people can claim on it. And I'm just going to touch on that because we're really talking about how to structure your estate better so that these things don't happen, of course. So there are 2 main ways that people can make a claim against a will. The first is that the will is invalid, and it can be invalid if testamentary capacity is in doubt or ruled that there was no capacity to make a will, or a will could be invalid if it hasn't been executed properly. So that is the first way that a will can be challenged, and the other way is through a family provision claim. So when someone feels like they haven't been adequately provided for, they can make a claim to the court to say, well, the will needs to be altered to provide more for me. Now, each state is different as to who can make those sort of claims. It is quite narrow in Queensland as to who can make those claims. So we have testamentary freedom in Australia, unlike some other countries. So we can do whatever we like in our will. However, the law then has an overarching moral obligation on us to say, well, yes, You can do whatever you like. However, you do have an obligation to certain people in your life. And the law sets out in Queensland that we have an obligation to our spouse, our children, and anyone else who might be financially dependent on us. So those are eligible people who could make a family provision claim if we leave them out. And children do include stepchildren. It doesn't include grandchildren. It doesn't include brothers and sisters. It doesn't include your parents. It doesn't include nephews or nieces. It doesn't include the lady down the street that helps you with the shopping, or the carer that pops in 2 times a day. So those sort of people are not included. So there you go. Those are some of the things that we really want to prevent in the planning process. So for capacity, I may ask people to go and have a capacity test and leave that on the medical file. I may actually write to a doctor and get them to give me an assessment. Of course, if you do a will professionally, you're not going to have any of the formality issues. Surprisingly, though, with electronic signing, that has been removed from Queensland. So we were only allowed to electronically sign wills and powers of attorney in Queensland very briefly in 2020 during COVID. It's the only state that has subsequently removed that. So it will be interesting to see whether wills signed during that period using that electronic means will stand up over time. So moving on. Estate planning in 2025, it is more than just a will. So maybe 40 or 50 years ago, people got away with just doing a will. And a lot of people ring me and say, oh, it's just a simple will. However, we want to make sure we look at what property is owned to make sure the will actually captures what you own, because there are estate assets and there are non-estate assets. So you may assume that something would be captured by your will and it isn't. There's, of course, a lot more tax and different taxes these days than there was decades ago. There is superannuation, which is highly regulated. And for most of us, it's one of our biggest assets when you also count in that there's likely to be life insurance on that. Powers of attorney are really important as well. Less and less people die suddenly these days. We usually have a period of declining health. Or even if we are injured in an accident or have a stroke or something like that, we're less likely to have that to be catastrophic, and we're more likely to survive. So power of attorney covers a period when you have lost capacity, but you're still alive. Advanced healthcare directives can be really important if you want to have more say in your healthcare should you lose capacity. Trusts are being used more and more, not only in wills, but also in life. So there's been lots of people running businesses through trusts, owning property in trusts, using trusts for all sorts of joint ventures and other development sort of activities. So those assets are not covered by a will. We have to make sure control passes to the right people. And then, of course, testamentary trusts are another thing in themselves. We can create all sorts of testamentary trusts. And when I say testamentary trust, a lot of people automatically assume a particular type of trust, but in fact, any trust set up in a will is a testamentary, whether that is a right to reside, a minor's trust, or a discretionary trust, a protective trust, special disability trust, all sorts of trusts we can utilize depending on your situation. Guardianship is really important as well in estate planning. One of the reasons I went into this area in the first place is because I wanted parents of young children to actually take care of what will happen to their children if something happened to them. So it was probably 2013 or 14. I had a friend who was a prosecutor down in Melbourne at the time. She was doing the sentencing for a woman who had run a red light about 18 months prior. No drug or alcohol involved, just a fluke accident. This poor woman ran the red light, killed a couple. So poor couple as well, of course. That couple had come down to Melbourne for the weekend to watch an AFL. They'd left their young children at home in Sydney with grandparents. So at the sentencing, there had been victim impact statements done to take into consideration. So there'd been statements prepared on behalf of those young children who had been in and out of family court for the last 18 months because one side of the family, the grandparents had separated, hated each other, wanted the kids, wanted to control the money, and the other set of grandparents hated those grandparents. So it was just a nightmare, and it would have been so easy to effect with a very simple will. So guardianship's super important. Having godparents is not a legal appointment. Aged care, they're now saying that aged care is more expensive than raising a child. We're not planning very well for it. How do we take into account what assets we have in preparation to look into aged care? Aged care reforms are happening again this July. Fees are going up. So it's something that really does need to be planned for as part of estate planning process, and digital assets as well. So over the last 20 years, more and more of our life is becoming digital. Where are all our photos kept? Where are all our emails and correspondence kept? If we are artistic in any way, do we have art, writing, intellectual property that we've developed? Where are we storing all this stuff? What are we putting up onto platforms like Facebook? What do we want to survive after we pass away? Do we still want our profile to be there? What do we want our family to be able to recover? So digital assets are really important, but also accessing those. A lot of the companies we deal with online are not Australian companies. They don't necessarily recognise Australian powers of attorney or Australian probate. So we need to address that as well. Hence, it's becoming a little more complex. So what happens if we die without a will? Rules of intestacy. They're different in every state. If you die intestate, it doesn't mean that everything goes to the government. But we've got some strange rules here in Queensland, which may be a little bit out of date. But that's what happens if we don't do a will. So if we have a spouse and no children, it all goes to the spouse. So that's pretty good. Unless you've separated from your spouse. If you're not divorced, your separated spouse is still your spouse for these laws. So separated people need to do wills. So if you've got a spouse and children, you get the spouse gets the first 150,000, and then the balance is divided between the spouse and the children. So that's not ideal. 150,000 is not much. And then the spouse would get either half or a third, depending on how many children there was, of the balance. Not really sufficient. If someone passes without a spouse or children, so think about young people who don't have a spouse or children, everything goes equally to their parents, their biological parents. So again, if they've grown up with a parent that's estranged and been separated, no, it doesn't go to their step parent that they love. It goes to their parent that they haven't seen for 15 or 20 years. If someone passes away, no spouse, no children, their parents have already passed away. And we do see some older people like that have never married, never had children. Parents have passed away. Their brothers and sisters then share equally. And if any of their brothers and sisters have already passed, then their share goes down the line to nephews and nieces. Long shot, young person passes away, their parents have also passed away, grandparents. Further abroad, uncles, aunts and cousins, and then only if someone is the very last end of the line in their family tree would it go to the government. But you can still that this process might work in some limited situations, but in very few. So we want to make sure those 5 things that we spoke about at the beginning, the 5 steps to protect your legacy, that we have the right people acting, that we make sure all assets are actually accounted for, that we can minimize the estate to avoid claims, that we look at as many scenarios as we can. We can't often cover everything, all ifs and buts, but we can get quite broad, and to protect beneficiaries from themselves. So, important roles in your documents to be thinking about. I don't think beneficiaries are the primary thing to be thinking about. I think beneficiaries are sometimes the easier decision. Executors are often the most important role. So executors, and you can have up to 4, and then you can have alternates just in case. They are the ones that actually administer the estate and collect the assets in, keep them insured, pay the bills, maximize what they can get, invest things if they need to, and then make sure the will is followed. So beneficiaries can also be executors. Sometimes people think, oh, I want to leave everything to my children, but I can't have them as executors. You can, but then you need to think about your family dynamic as well. That's where I can help guide you, but you know their personalities best. So sometimes it's not best just to stick them all in and say, well, they'll work it out, because you already know that there's a couple of the kids that don't get along real well. There's one particular one that's quite controlling. As soon as children sometimes have to start working together, all the niggles from their childhood end up popping up. So you really do need to think about family dynamics, personality strengths, who can actually get things done. There are executors that put their head in their sand and years later problems arise. There are executors who have conflicts of interest, who then don't administer the estate because it's not in their interest to get it finished. You can appoint professional executors. However, I always recommend to have at least 1 or 2 family members or close friends in as executors along with a professional, because a professional will charge for their time. Executors aren't automatically entitled to commission, but you also need to think about leaving something for an executor if they're not otherwise a beneficiary as well. They can ask for a commission, and the court can grant them commission if the estate is quite complex. Executors who you appoint often end up becoming trustees. So it can, again, be a very long ongoing process. So if you have children who are underage or grandchildren who are underage that you were leaving things for, your executors end up holding those funds until your beneficiaries are old enough. So they become the trustees, and that is what's called a minor's trust. So it's held until the minor reaches the age that you specify. Quite often there are rights to reside, or there are other testamentary trusts that the executors might end up being trustees for years as well. Guardians, I've touched on briefly. Very important to think about who could be guardians. If you are leaving your children in someone's care as a guardian, I prefer that people select one person so there's not a joint issue. So one really trusted person. That person could also then be one of your executors as well, but make sure you also have an independent person working with them, because the guardian is going to have some powers to be able to dip into the inheritance and funds that are left for any children to help educate them and bring them up. And we don't want a conflict of interest situation there either. Of course, if you have a primary guardian, you can also have a backup one just in case the first can't. So there can be a sort of sequence of whom you appoint there. Beneficiaries sort of goes without saying, really. In some ways, think about who you want to leave what to. I'll talk a little bit more later about classes of beneficiaries rather than specific beneficiaries. Consider charities further down the line if that's something that you want to leave a legacy for. Some people ask me about setting up a charitable trust in their will, but I tend to try to get people to leave to an existing well-established charity that's not going to fold, because setting up some kind of charitable trust in your will can be expensive. And then attorneys, really important as well. I've briefly touched on having an enduring power of attorney in place. So the attorneys have a very similar role, I suppose, to executors, but while you're alive. So an attorney has to do what's in your best interests and manage your affairs for you while you're alive. They can't act in conflict with that, so they can't give themselves money. They can't gift your money away to third parties either. Has to be in your best interest. They have to keep pretty detailed records of what they're doing. So again, a really trusted person or multiple people. And I generally advise people, once you've decided on your executors, that's probably a fairly hard decision, follow that with your attorneys as well. Similar people, because if you are declining in health and that leads to death, the attorneys have already been acting. They already know what is what and what you have. And then it's a continuous roll then through to executors. All right, superannuation. One of our biggest assets for a lot of us, and it is not automatically covered by your will. Or not automatically, it can be, but there are various situations. So sometimes it's great that the superannuation is not covered by your will. If there was some kind of potential looming claim that you were anticipating on your estate, we're trying to minimize what would be in your estate to minimize what could be claimed on. And so superannuation is one of those things that we can leave directly to beneficiaries without it going through your will. So, you know, if you've got hundreds of thousands, millions in super, including life insurance, you can name a spouse or particular children. The categories are limited who you can name, but you can do that so that it goes directly and doesn't go through your estate. So that's where it comes into doing a nomination. Binding nominations, I believe, are the way to go. The non-binding nominations, they're not worth the paper they're written on, because a trustee will look at them and has recently in court cases disregarded a binding nomination, just done their own thing. So when there is no nomination, or the nomination is non-binding, or a binding nomination has lapsed, so they're often only good for 3 years and you have to redo them. So if a binding nomination has lapsed, it's then non-binding. A trustee of a super fund can make their own call. I do not like uncertainty. I want to know what's going to happen. It's my account. It's not like the trustee won't pay it out, but the trustee can then call for applications from family members and they will determine the proportions and percentages. So who can the trustee pay to? The trustee can pay to dependents. So dependents include spouse and children. Even if they're not technically financially dependent, that's what the definition is, and someone who may be financially dependent. So if there is someone who might be a grandchild, for example, living in your home who is financially dependent, they would be included in that as well. So those are the people you can name directly on a binding nomination, or you can name into the estate. So you can then, if you wanted to, on a binding nomination, actually say you want it paid into the estate, and then it will go through your will. Tax dependents are different. So understand that if you pay superannuation directly to your spouse or to your spouse through your will, there is no tax to pay on super. if superannuation goes to children who are under 18, or sometimes children up to 25 who are still studying, that is also tax-free. Adult children pay tax on superannuation. On the taxable component, that's something to talk to a financial planner or accountant about, trying to reduce the taxable component in your super if that's what you're worried about. For those of you who are just popping in, welcome. Yes, there's a recording, so don't worry too much. You can go back and watch the beginning. We're really just getting into the nitty-gritty though too, so good time. So superannuation, as I've been saying, one of our biggest assets, can't be missed out of the estate plan. So it's not just about doing a will. Coming down to powers of attorney as well, so you know a little bit more about those. So in Queensland, we've got 3 types that are considered powers of attorney. So you can do a general power of attorney. These are fairly rare. Potentially if someone was going overseas and there was a transaction and you just wanted to appoint someone for a particular thing for a certain period of time, a general one would be fine. But it's the enduring powers of attorney that we do more often. It's called enduring because it endures past us losing capacity, which is the main reason we do it. A general power of attorney would finish if you lost capacity, because under a general power of attorney, the person has to act in with your instructions. So once you can't give instructions anymore, it ends. Enduring power of attorney, you're appointing someone you trust to act for you once you have lost capacity. The enduring power of attorney in Queensland also covers some healthcare decisions as well. Or you can do the additional advanced healthcare directive as well as the enduring power of attorney. The advanced healthcare directive allows you to make more detailed notes and choices and instructions. It is signed off by a doctor. And if your medical team knows about your advanced healthcare directive, they have to follow your instructions without even talking to your attorney. So if there's an emergency and they know what you want to not be revived or whatever, they have to follow that. So in making these documents, we need to think about when they begin. So with an enduring power of attorney, for example, you can have it begin immediately. However, of course, you're not giving your own power away. While you still have capacity, your attorney has to act in accordance with your instructions. And when you lose capacity, it continues and they have to act in your best interests. Or we can also say it begins on a certain event happening, or we could say it begins once you have lost capacity. And so it would be dormant until a doctor has given a certificate. The difficulty with that is that doctors can be either too fast to issue a certificate or really reluctant to issue a certificate, because there are lots of conditions which could affect us cognitively, but not to the point where we can't manage our own affairs. It might only be in certain situations we shouldn't be doing our own affairs, but not everything. Or sometimes you're fine in the morning, but too tired in the afternoon, or, on different days you have different capacities. So sometimes immediate is better, because then your family chooses, and that's why appointing the right people can be really, really important. So do you appoint a single person or multiple people? And how would you have them act? So just like you can with executors, you can have up to 4 attorneys, and you can have them so they have to act by majority, for example. You can have them so they all have to act jointly. So then you have an extra level of protection potentially. Or you can have them be able to act individually. I tend to think have it as easy as possible and practical as possible for those who are helping you out. And if you're appointing people you trust anyway, have them be able to act separately if they need to, because it can be quite difficult trying to coordinate 3 or 4 people to countersign every time there's a bill to pay. All right. So coming back to capacity again, which I've touched on earlier. So remember, there was 2 ways that a will could be challenged, and one of those is whether it's valid or not. And it can be invalid if we say that, or if it's found that there is no capacity. So we like to remove any doubt and make sure that what we do is limited to be able to be challenged. And in doing that, we will often send someone off either to make sure that there's a capacity test on their medical file, or we'll send a letter to a doctor for an assessment. However, that being said, capacity is not a medical test. So a lot of the medical profession will think that what they say goes. However, it's a legal test. And so even if a doctor says that someone doesn't have capacity, sometimes the court has found that no, they do have sufficient capacity to make a will. The test is fairly low. So just because someone has a diagnosis of dementia doesn't mean that they don't have capacity to do a will. Just because someone has had a stroke or has Parkinson's disease or some other kind of motor neuron disease or degenerative condition doesn't mean that they don't have capacity. It is a personal test on every single situation. And so the medical test is helpful. So we get that as a backup as well. However, because it's a legal test, I also make my own capacity assessment and have to go through a process of keeping quite detailed information about the questions I ask and how they're answered. So the test for capacity to do a will is literally, do they understand what a will is still? So it's fairly easy to describe. Yeah, it makes sure that after I die, what happens to what I want happens, or, you know. So it's quite easy for someone to remember and be able to describe that. They have to understand what assets they have. So if someone's situation has been simplified more and more over time, and all they have left is their house and some money in the bank and their car, or potentially no car anymore, or the house is sold and they're in aged care, and so they've got a bond and money in the bank and that's it. They don't have much complexity and they can understand what they have. And then they have to understand their family dynamics and the consequences of the decisions that they make. So if they do want to leave someone out, it becomes more complex. So you need higher cognitive function to be able to make that decision. But if a will is very similar to a previous will that they did 10 years ago, and you know there's no one being left out, then someone with dementia can still make a will to that effect. I'm just going to jump back to one of the questions that has popped up. It was about enduring powers of attorney, which was what I was talking about just before. They are all state specific. If you move states, you don't need to update them. The states recognise each power of attorney, but if you do update, you of course would then update in the state that you're living in. Enduring powers of attorney are fairly common and similar across all states. So they generally cover the same sorts of things. They generally have the same when they begin and the same sorts of powers. In Queensland, it also includes health decisions. In New South Wales and Victoria, enduring powers of attorney do not include health decisions. So there's a separate document in those states for health decisions. But it's not invalid just because you've moved states. Same thing with any of your documents. If you move, not even states, but just move house and your address is different in your document, it does not invalidate your document. So you don't need to update a will or powers of attorney just because you've moved. All right, so talking further about claims again as well. So we've just talked about the potential of an incapacity issue or someone claiming that the will is invalid because of incapacity. The second way that someone can make a claim against a will is to say that I haven't been provided for sufficiently. And for those who came late, I did go through in detail who was eligible for that sort of a claim earlier. So now we're going to talk more about minimising risk, because if you do want to leave someone out who is eligible, there are things that we can do, and quite detailed sort of planning that we can do to make sure that your estate is not, well, to make sure that it's certain for you. Basically, we're trying to minimise your estate, because the less that is in your estate, the less can be claimed. So we look at trying to turn your assets into non-estate assets, so they're actually not covered by your will. And interestingly, all states except New South Wales can do this. In New South Wales, they can claw back what you do during your life, so it can be still available to be claimed against. But in Queensland, what you change during your life to prevent a claim stays, and it can't be clawed back. So what can we do? Well, joint assets is a way that we do a lot of these sorts of things. So on a house or on bank accounts, the joint owner who survives is the person who ends up owning the property. So if you've got a joint bank account, and one person passes away, the bank account doesn't freeze, it automatically becomes the other person's bank account. On real estate, if you own it jointly, not as tenants in common, so joint proprietors, it transfers by survivorship to the surviving person or persons on the title. So more and more we are adding children onto titles with mum and dad, or just with mum who's left, to remove the real estate from the estate if there is a child who might make a claim. There are stamp duty implications, but sometimes it's worth paying that up front to prevent a claim of, 100,000 or more, and legal fees. So transferring assets during life is sort of what we're talking about. So either joint assets are bought that way or set up that way, or we transfer them during life. So we can transfer real estate, we can add people to bank accounts, we can do those sorts of things. Discretionary trusts and other entities are also assets that are held by trusts and companies are not estate assets. So a lot of people would have a trust which becomes an investment trust, and they're buying their investment properties into a trust rather than their own name. So all those properties would be protected from any claim against a will. However, of course, if you'd already bought the investments in your own name and then wanted to move them into a trust, there's stamp duty and capital gains impacts of that. So it's really about having the foresight to do it early rather than trying to fix it later sometimes. And as I said earlier, with superannuation and life insurance, you can often nominate a specified beneficiary, and so then it won't go through your estate at all either. Testamentary trusts can be a way to minimise family provision. So you might not want to cut someone out completely, but you might not want them to have control of what you're giving them. So you could leave it in a testamentary trust with multiple beneficiaries and someone else in control. So they might jump up and down a bit that they don't have the money for themselves, but they've got no family provision claim because they have been provided for. So that's another way of doing it, setting up a tricky trust in the will for it. Right. So what is a testamentary trust? So I have covered on this a little bit. Sorry, I'm just trying to find my mouse. There we go, because there was another question. Donna, Western Australia, I'm actually unfamiliar with the powers of attorney in Western Australia. But when I say all states recognise each other's documents, Western Australian documents are recognised here and vice versa, so that's all fine. And wills anywhere in Australia are recognised as well. So if you moved from Western Australia to Queensland, your Western Australian will is still valid. or vice versa. So not too much of a problem there. So testamentary trusts, this is more about a testamentary discretionary trust. So when you want to leave funds to a person and protect those funds from themselves, a testamentary trust is often the way to go. So there might be reasons why someone needs to be protected from themselves. It could be that they have a drug and alcohol problem. It could be that they have a gambling problem. It could be that they have an intellectual disability. And in those situations, it's not a straightforward testamentary trust, but can still be used. So those sorts of beneficiaries, often it's not ideal for them to have control of large amount of finances for themselves. So we can put trustees in control of their part and put it into a testamentary trust. So because a testamentary trust is created in your will, it's dormant and it sits in the will, and it isn't triggered and started until you pass away. And then your executors would set it up and fund it with the inheritance through the will. So there's not much initial cost. It's just a part of the will preparation process itself. The terms of the trust get written into the will. And then, as I said, it's dormant and it just sits there. So there's nothing ongoing. Once the will, once you've passed away and the testamentary trust is triggered, then there's no more establishment fees at that point. It's really just setting up bank accounts for the trust, getting a tax file number, potentially an ABN if it needs to, because it has investment properties or something like that, and then doing an annual tax return each year. There's no major auditing requirements of a testamentary trust like there is on superannuation. So it's not a heavily administered sort of vehicle. And then if we have a fairly relaxed testamentary trust, it's very similar to the sort of family trust that you might set up while you're alive. So broad classes of beneficiaries, because one of the benefits of a testamentary trust is broad income distribution over time. So if you are giving your child an investment vehicle with their inheritance, this investment vehicle may outlive them. So it can benefit future generations as well. And you want it to be broad enough to be able to, for example, if you leave your inheritance, the inheritance to your children in a testamentary trust, for their children and their grandchildren and so forth down the line. So the benefits, I've just talked about income splitting. So that is a broad class of beneficiaries that you can distribute income to. There's also asset protection. So this is the main reason why people think about a testamentary trust. Their beneficiary doesn't really have any issues in their life. They're fine to manage their own funds. It's just better to have those assets protected, potentially from a future spouse or a separation from a current spouse. Or even if they're in business or in a professional role, from bankruptcy, insolvency, or professional negligence claims. So any inheritance that goes into a testamentary trust is safe from those sorts of claims. The family law courts in a separation situation do have fairly broad powers, but we make sure that it's less likely that a testamentary trust will be set aside and attacked by an ex-spouse. At worst, it would be considered a financial resource, but it wouldn't be split open. So it is a practical way to set inheritance up for minor children, particularly if you want the trust to last for quite a while, for young adults who need someone else to run it for them, or just, as I said, children who might be in business or professional roles, children who might have sort of a bit of an unstable marriage. And then, as I said earlier, beneficiary wise, we can make it really broad or we can make it quite narrow. So if you didn't want the spouse of your children to be able to benefit, even if they were on good terms, you can narrow it down so that they can't. You could have what's termed sometimes as a bloodline trust, so that it only goes to children, grandchildren, and down the line like that. But quite often I'd prefer a little bit more flexibility than that. But yes, you can rule out spouses completely as well. And you can exclude certain people from being able to have control. Another little question just popped up. Do you need a capacity test every time you revise your will? I think that once you start, if there's any question about capacity, then yes, every time you update your will, you would want a new capacity test, because there's also the assumption that whatever the disease is declining. So the capacity is likely to be getting worse. So yes, doctors who might have a concern about capacity are often doing mini mentals regularly. So that's getting filed anyway. And that's often sufficient. So it's fairly rare that I'd write to a doctor and ask for a specific medical assessment to be sent to me anyway. I just want to make sure that there's something on a medical file that we can subpoena if we need to. Ooh. All right. Some little myths and tricks and tips and things that are sometimes a little bit, interesting little things potentially. So the reason when we do wills for a couple that we like those wills to be mirror image is because if the couple passes away together, it's the youngest person's will that is followed. The oldest person is deemed to die first, so their wishes are pretty much disregarded and it follows the youngest person's will. So that's why we want a couple's will to reflect each other, so that the wishes of the older person is also reflected in the youngest person's will. Marriage, separation and divorce affects a will. Marriage invalidates your previous will altogether. So if you haven't redone your will since you got married, it's probably a good idea to do it, or you will die intestate. Divorce does not invalidate your previous will. What it does is kill off your spouse, your ex-spouse, essentially. So it deems your divorced spouse to be dead in terms of reading your will. So wherever they are named, you essentially cross them out. And separation, which I touched on earlier, is really when a new will needs to be done as well, because separation doesn't invalidate your previous will. If your previous will left everything to your spouse and you separate, it's still valid and it leaves everything to your spouse. And even if you've separated, they're still legally deemed as your spouse for superannuation payments, for claims against your estate and all those sorts of things as well. So that's fairly crucial. The 30-day rule. So when you pass away and you leave funds to someone, they need to survive you for 30 days to take that benefit. Otherwise, that gift lapses and it goes down the line. The forfeiture rule. Now, if this one sometimes gets a little bit of an awkward laugh, because sometimes parents are a little bit worried that their children are starting to ask about their inheritance and starting to move them on a little quicker. If someone is responsible for your death, they are forfeited out of your will, so they will not receive any benefit. And it doesn't have to be to the level of a criminal. It can just be negligently responsible for your death. A gift over to children. So this might be a little bit relevant in thinking about the 30-day rule. So a gift over means that if one of your children passes away before you or within 30 days of you, the gift over rule says it goes to their children. So the part that would have gone to your children goes automatically to their children, unless you say you don't want that to happen. That gift over does not work for anyone else in your life. So if you leave something to your brother and he dies before you or within 30 days, it does not go to his children. You have to specify if you want it to. Similarly, if you left something to your grandchild and they passed away before you, it does not go down the line to their children. It's only children to grandchildren. Residue is your estate that is not specified. So it's everything that you haven't specifically said. So your residue is the bundle of your estate, essentially. We want to make sure that we give all of it away. You can give it away in dollar amounts, but we don't necessarily know what it's going to add up to. So I'd prefer to deal in percentages. And if we're dealing with percentages, we need to give 100% away, not 9 of 10 shares or 8 of 9 shares or miss like 5% or something like that. We need to make sure we give 100% away. Specific and general gifts can be interesting as well. So a specific gift is a certain thing which is quite clear. So you can say my engagement ring, my certain piece of artwork, my particular piece of crystal, whatever it is, that's specific. And it needs the word my because it's what you currently own. Because if you don't own it when you pass away, then the gift lapses. Whereas a general gift is, an example might be, I often use this, my sister would love a red Ferrari. I don't own a red Ferrari, so I can't leave her my red Ferrari in my will. But in my will, I can say I leave my sister a red Ferrari, which compels my estate to buy my sister a red Ferrari. Obviously, that's not something that most people would do. The thing that might be done is I leave each of my grandchildren 20 BHP shares or something like that. You don't own them. It requires the estate to buy them. Specific or classes of beneficiaries. So I touched on this briefly earlier as well. If you want to leave something to a specific beneficiary, of course, you name them, then they're specific. And you can also describe them as well. So my husband, Daniel, or my sister, Alana. A class of beneficiaries, though, is where you say my grandchildren or my children. So if you say I leave everything equally to my children, it's whatever children are surviving you at the time. The gift over rule would then apply. If one didn't, it would go down the line to their children. But that works differently. For example, if you leave everything to your grandchildren. So I leave $20,000 to each of my grandchildren, but your children haven't finished having children when you pass away. So there's more grandchildren born after you pass away. Unfortunately, those children born after you pass miss out because the class closed when you die. So it's only the grandchildren as at the date you pass. Mutual will contracts are interesting too. So this is done between spouses. So it's a contract between a husband and wife that they agree to do their wills in a particular form, and they won't change their will without the consent of the other spouse. So if one spouse then dies, the other spouse cannot change their will. So this is often used where particularly a wife is concerned that the husband will quickly go and get another spouse after she passes away, but she wants to make sure that their children get everything and his new spouse won't. So that is quite often used in that situation. That's a really specific question. And you're probably going to have to email me that one. A distribution from a testamentary trust. I'll take that and get back to you. All right, so nearly at the end. My details are there. So that's the email to use, jackie.broman@spglawyers.com.au. I've also put Tony's details there because he's the one that does the litigation if all of this goes wrong. But before we get on to questions and answers, I quickly wanted to show you the standard fees as well, so you sort of know what this sort of process takes. So just wills, which I don't believe is sufficient, is about $1,200. This is for a couple, not each. The family legacy plan, which is the basic package, which has wills, powers of attorney, superannuation, an assessment of your assets, that's $1,850 for a couple. And then if you want a testamentary trust, you're looking at the family protection plan. So that's the sort of range to bear in mind. Now, there are a couple of other questions as well that I thought I'd touch on while we're still in the recording. So I've touched on the cost of setting up a testamentary trust is built into these costs, the cost of setting up the will, because the testamentary trust is dormant until someone passes away. I had a question around stamp duty and capital gains exemptions. So in Australia, we do not have a death duty. We are still incentivized to transfer our wealth on death rather than during our life. So there are exemptions on stamp duty and capital gains tax to give effect to the will. So if that includes funding a testamentary trust, then there's no stamp duty and capital gains on what goes into that testamentary trust as well. And then that's all. The other question was around a foreign beneficiary. So some of those exemptions go out the window as soon as there's a foreign beneficiary, particularly for capital gains tax. So if you're giving cash to a foreign beneficiary, that's fine. But as soon as there's assets transferred to a foreign beneficiary, you can start having problems then. Depends where they are, of course, too. And I've covered off as well on executor appointments. So it was a question around having a solicitor or another professional as an executor. Generally, though, the preference is to try and have personal contacts, family or beneficiaries as executors. They're usually going to engage a solicitor to help them through the process, and that solicitor doesn't have to be an executor to do that. So that's another part of a lot of the work that I do, is executors engaging me to do probate, to transfer land, to sell land, to gather in the super, to close bank accounts, all those sorts of things. Probate is not a tax. Probate is the process of getting the will endorsed by the Supreme Court, basically, for an executor to do their job. All right. So I'm going to end the recording. Thank you to all those who are watching the replay. You've got my email address, so you can email me if you have questions. The process of engaging me is similar. Email me, it's the best way to get in touch, because then I can give you a range of potential initial appointments, and we can go from there. And so let's end the recording and allow question time. Screen share.